All right, good morning all. We're here in the self-represented family law docket. I'm Judge Evans. Welcome to Ms. Bennett. And
Yes.
Brandon, are you on? So friendly reminder for everybody who's not actively on this particular call, make sure your phone or device is muted. All right, so Ms. Bennett is here. Again, I'll call out for Brandon Hicks. Brandon Hicks, are you on the line? All right, not hearing a response from Mr. Hicks. Taking a look at the case, this is on for a motion for temporary parenting plan. I've reviewed the documents that Ms. Bennett that you filed, and also it looks like Mr. Hicks filed a response and indicating that he had previously filed a motion similar to the one that you had filed in Columbia County. So usually what happens in events like that, when both parties have filed in different jurisdictions, there needs to be a conference between the two judges, between myself and the other judge in Columbia County, to make a determination of which jurisdiction or which county is going to have jurisdiction and which will take the case. So just so there's not competing orders. So the way we do that is that I rely upon my assistant. She contacts Columbia County, makes an arrangement with the judge there. You and the other party are notified of the date and time of that. It's on the record, it's recorded, it's open to the public. And then we would have our discussion in front of all of you. And it looks like Brandon there's a Brandon coming in right now. So let's pause for a second. Brandon Hicks, are you on the line? I see a Brandon on there that's spelled in the center. Okay, Mr. Hicks, can you hear me okay?
Yes, sir.
Okay, I just called your case and I was just in the middle of explaining the next steps that we're going to take, and I saw that you were coming into the call, so I paused. So I'll just restart.
Yeah, I was trying to get logged in.
So Ms. Bennett is here, and she has filed a motion for a variety of orders related to the parenting plan, child support, and the like. And I saw that you filed a response, and you indicated that it looks like in October, September, you had filed a motion in Columbia County for similar types of relief. So in situations like that, we have to do what's called a UCC-JEA conference, which is a conference between myself and the Columbia County, Oregon judge, to make a determination of which court is going to make the determination and which county gets the case. So the process for setting that up, I rely upon my assistant. She contacts the judge over in Columbia County. She establishes a time with him or her. We notify you and Ms. Bennett of the time and date. It'll be on the record, and you can both attend via Zoom and hear the discussion and hear the determination. So,
okay.
So what that means is that today we're not going to be hearing the case because the jurisdictional issue still remains to be resolved. So what I want to do is make sure that we have proper communication, contact information for both parties. Mr. Hicks, it looks like you've got a phone number ending in 2374.
Yes, sir.
Okay. And then for you, Ms. Bennett, it looks like we have a phone number ending in 5878.
Yes.
Okay. So my assistant is really quick on these things. Sometimes it takes a little bit of time from the other side to figure out the date and time. Let me just ask while we're looking at this, Mr. Hicks, you filed copies of the documents that you filed in Columbia County, and it looks like it was assigned to a Judge Keppinger.
Yes, I do believe that's right. Okay, I don't have the documents in front of me right now.
Yeah, it looks like they were filed, and you filed it in this case, and I've got a cause Judge Denise Keppinger.
Yes, sir.
Okay. Okay, so that's the process. I'm not exactly sure when that UCC-JEA conference will be established. Usually it's within no longer than 2 weeks. So let me just ask Ms. Bennett. Ms. Bennett, do you have any questions?
Nope.
And Mr. Hicks, do you have any questions?
No, sir.
Okay, my assistant's name is Sylvia Workala, so she'll be reaching out to you either via phone or email and letting you know of the date.
How do states with no personal income tax raise money for public services?
Ms. Farrell, will you please make sure that you're muted? Again, I'll just remind all the parties that are on Zoom, please make sure you're muted. Slows things down when people interrupt. All right, so Ms. Bennett and Mr. Hicks, that's kind of where we stand at this point. So we'll be in touch and we'll set that date and I'll let you know, and look forward to having you both there observing and hearing what the decision is.
Thank you, sir.
Great, thank you.
All right, that'll conclude that for today. She was there earlier.
Yes, I'm on the line.
All right, welcome to you, Ms. Farrell. And Evan Huffman, are you on the line?
Oh, yes, I'm here.
Okay, great. Welcome to you, Mr. Huffman. We're here today related to kind of the jurisdictional issue that we talked about last time, whether or venue more appropriately termed. And I asked the parties to draft an order, and I'm not sure if I've received some orders, proposed orders from Ms. Farrell. Really what I need the parties to do is get this document into your hands. So I have a document here. It's a proposed order, and it's an order transferring venue to Calais County and consolidating the Lewis County matter with the Calais County matter. So let me just read it to you so you know what it says. It says, based on the agreement of the parties, the court orders the following. Venue of the Lewis County cause one is hereby transferred to Calais County. The Lewis County cause one shall be consolidated with Calais County cause 24-3. So this is a document that needs to be signed by the Lewis County judge. And so I have it, and I need signatures from both of you. And then once I have your signatures, then I would forward it to the judge up in Lewis County, and then the judge in Lewis County would sign it and then get it back to us. At that point in time, then we're properly positioned to move forward with the requests that are pending. So I recognize it's taken a little bit of time, and I apologize for that delay, but we kind of just need to make sure things are done soundly and properly. So I just want to talk to the parties about your availability to come to the court to sign that document. I'll first ask Ms. Farrell, when would be your earliest convenience to come to the courthouse and sign that document?
I can do it today.
Okay. And Mr. Huffman?
Excuse me. My little brother, he's at a dentist appointment right now, but as soon as him and my mom get back, I would be able to drive down there and sign it.
Okay, great. Great. What I'll do, I will give it to our receptionist, and you'd come to the Hall of Justice, go to the second floor, and go all the way to the north end of that second floor. And there's a double doors. You'd pass by the clerk's office, and there's a double door, and you hang a left, and then off to you'll see a little sign that says Superior Court at reception or administration. Denisha is the receptionist. She'll have that document there, so just sign it, and then once you have signed it, then we'll ship it up to Lewis County and have the judge sign it and have them send it back to us as soon as they can.
So it's going to be in Calais County, that like the papers are going to be in Calais County that we have to sign?
So yeah, just making sure we're on the same page, is that this order that I just read to you about the venue moving from Lewis to Calais and the consolidation. Yeah, the case is going to be heard in Calais County Superior Court. And then all further proceedings or future proceedings are going to be here, because the Lewis County matter basically merges into the Calais County matter. And so it just becomes one, and the Calais County matter then moves forward. And the Lewis County basically just kind of ceases to exist and gets subsumed or swallowed up, if you will, by the Calais County cause. Does that answer your question okay?
Yes, I was just making double sure.
Yeah, that's fine. Yeah, I appreciate the clarifying question. All right, so let's, I don't want this case to get lost. So what I'd like to do, if you're both coming in today, that's fantastic, and I appreciate your flexibility. We can get that out in the mail probably at latest tomorrow to the judge, and set it for March 13th to come back to hear the motions that are pending, the parties want resolved. So are you both available on March 13th at 9 a.m., Mr. Fred?
I'm down.
Yes.
Great, thank you. Mr. Huffman, are you available on the 13th?
I should be available. Do you care if I have 1 second just to look at my calendar really fast?
Sure.
Thank you. Yes, I'm available on the 13th.
Great. All right, very good. We'll come back on March 13th at 9 a.m. and hear the motions. I'll ask if Marcus
Great,
Ruby
thank you.
is on the line. It. He's in the court. Ms. Ruby, come on up and take a seat. Either side where you no preference, and just make sure you're positioned well in front of the microphone. You can slide it in front of you, and it doesn't amplify, it just captures your voice. All right. Perfect. Good to have you here. And then I'll ask if Samantha Granzo Carranza is on the line.
I'm here, Your Honor.
Okay, well, welcome to you. All right, so we're here for several different things. It looks like Mr. Ruby has filed a motion related to a motion to transfer the case to mediation, a motion for a temporary restraining order to become permanent, and a motion related to a temporary parenting plan and the like. And it looks like their service was effectuated based on the affidavit of service, And I'll just
Your Honor, the only thing that I received from Kalama PD was the hearing notice. I have no other court paperwork in regards to this.
okay.
Just
I
old
have
ones.
messages saying that she received the restraining order paperwork.
Okay, let me double check and see what's in the file, and then I'll tell you what it shows. So I see there's a declaration of service that looks like David Kearney of Kalama PD filed. He said that he served a notice of hearing and an immediate restraining order and a hearing notice to Ms. Granzo Carranza. And I think that's probably what you're talking about, Ms. Granzo. Is that correct?
Correct.
Okay.
The paperwork that I was handed though, the immediate restraining order ex parte part is crossed out. So it's just it says and hearing notice. He said to disregard the immediate restraining order ex parte part. So I was really confused. I'm still really confused as to what it entailed. I just looking it over, it goes back to the restraining order that he had put in place back in 2002 or 2022, excuse me, that was dismissed after the 1 year of it being in place.
So, Ms. Granzo, I appreciate that input. Let's before we go further, I just want to make sure we're clear on the issue of notice and service. So I appreciate your input. And then Mr. Ruby had some input. Can you repeat that?
Repeat what I just said.
Yeah. Yes, please.
Oh, that I have messages saying that she got all of that. And then, yeah.
And those messages came from whom or where?
Samantha.
From where?
Samantha.
Oh, okay. All right. So what the court does, the court relies upon just any documents that's officially filed with the court. And so the one document that I have is, so there's a docket notice that Mr. Ruby caused to be filed, which says, hey, on the 28th of February, we're going to have a hearing. And we're going to talk about the parenting plan, the restraining order, and mediation. So he filed that. And so then I looked and then he also had a lot of other different documents. He filed a motion, a declaration in support of a parenting plan, a motion for a temporary family law order and restraining order. And so those documents were filed back on February 13th. And then I see the return of service, which would be the individual who takes those documents and then serves or gives them to the other party, in this case, Ms. Granzo. So this Officer Kearney says, I'm a police officer. I served the court documents to Ms. Granzo on February 20th at 10 o'clock in the morning. And he lists the documents. It was a temporary protection order and a hearing notice and a notice of hearing, which is probably the same thing as that he said before, notice hearing notice, and then an immediate restraining order, the ex parte, and then a hearing notice, which kind of sounds like the same thing. The hearing notice was mentioned a couple of times. What he doesn't mention or does not include in that is the motion that you filed regarding the mediation. That was not served, and your declaration basically where you're giving your explanation of what's happening with the kids, and then also your motion for temporary family law order, which was a 7-page document where you give some more explanation. That was not included either. It wasn't served, and so sometimes I'm not sure. Sometimes what happens with service, sometimes something gets lost in the communication, and officer only serves certain documents, but not all of the documents. So in order to have a fair hearing, both sides need to know what the other side is saying. So you've kind of given your piece, said what you need to say and what you want to say, and then now Ms. Granzo hasn't read what you've had to say. So if she doesn't know what you've said, then she doesn't know how to respond, because then you would have another opportunity to respond to what she says. So that's a lot of words to say. We're not going forward today.
Yeah.
So what that means is that there would need to be service upon Ms. Granzo of those additional documents.
Okay.
Probably just best to take all the documents that you filed and just have those reserved,
Okay.
and then have it noted up for a particular docket. Usually, it's a kind of a 2-week time frame that we all work off of. So if you, Ms. Granzo, so do you have any questions about that?
My only question is so with the restraining order part, what does that entail? Because up until the 20th, we were all doing just fine. Like the girls, I'll be able to respond more to his side of what he's saying when we come back for the matter.
Yeah. So the February 12th order, the temporary restraining order, says the following: that there's going to be a hearing today,
Mm-hmm.
and it involves, the temporary order involves two children that are ages 10 and 7. And there are no restraints other than that there's a restraint on Ms. Granzo to not take the children out of the state of Washington, and that the existing order of October 21st of 2022 is in effect. So
Okay,
so the 2022 order, let me pull that up, December 21st.
states I'm allowed no contact or anything with my kids at all.
So that order from October 21st of 2022 says Ms. Carranza shall be the primary custodian for Bethany and Annie. Mr. Ruby shall not have visitation with his children until 1, he provides a clean hair follicle test to the court and the guardian ad litem, and 2, he petitions the court for supervised visitation. So that was
I
the,
currently have custody of both the girls.
say again.
Oh, he only has because he doesn't have custody.
Oh, Ms. Carranza, hold on a second. I need to hear what he had to say and then you can respond.
I have custody of both the girls. I have a paper from Bethany's school right now. I haven't gone to Anna's yet. But I currently have both the girls enrolled in school.
Okay.
Like they're with me. They're not even with her.
But they do not live with him.
But
One
they-
lives with him and the other one lives with his sister.
So, Ms. Carranza, if you could hold off just 1 second, I'll let you know when it's your turn. So, Mr. Ruby, so there was that October 22, 2022
Yes.
order that states that. Has there been other orders since that time that
Not that,
says?
not that I remember, no.
Okay,
But like I said, I do have custody of both the girls.
okay.
No,
My sister has one of them because Anna doesn't like all the commotion. I have 5 of the kids in my house. So she does better with my sister, but she's still with us.
Okay.
Like,
So the question was raised, so what is the temporary restraint? The temporary restraint, I just reviewed that, so the parties can look at it yourselves from
I have a copy of it.
okay. So that's the order that's in effect now.
okay.
So service still needs to be effectuated with all those documents that you filed,
Mhm.
Mr. Ruby. So if you're, I'm making an assumption that you want to move forward with your motion, have it heard.
Yes.
So you'll need to get the full documents served to Ms. Granzo and give her an opportunity to respond. And then we could come back here on the 13th of March and address the issues.
Okay.
Any questions on that?
How does that work because both my kids don't want to go home.
Mhm.
Like, like I have voice last night from Bethany calling her mom, telling her she's just done with her because of all the stuff that's been going on.
So your question is,
Oh my God.
what do we do between now and the 13th?
Yes, because neither one of them want to go back home.
Okay. Right.
I'm not gonna make neither one of them come back home. The girls, Bethany got a hold of me, and excuse me, Honor, but my kids got a hold of me on the 19th of January, stating they did not want to come home. And at that point in time, I okayed them staying with their dad, staying with their aunt. I was okay with this. And then on the 20th, I got served with the restraining order and everything was fine prior to this. So I'm confused where all this comes into play. I'm just wondering, am I able to talk to my kids? Am I able to see them? That's what I.
Last night and you didn't answer.
So the only restraint that I see in the order that was signed, let me pull it up here again, just a second.
Okay, she had every opportunity to call the kids anytime she needs to. She's not blocked on anything, and she doesn't.
Okay. Yeah, so the restraint provisions just prohibit Ms. Granzo from taking the children out of Washington State, and that both parties must not move, take, hide, or damage, or borrow against, or sell, or try to sell, or get rid of any property. That's the only other restraint that's in place currently. So between now and then, there's no specific orders other than that October 2022 order.
Okay.
And so the parties, you can kind of just do your best to make sure that the children are safe and well taken care of, and you can figure that out. And when we come here on the 13th, we'll have a full hearing in the court to make this. Okay.
Can I ask one quick question before we
Sure.
is Amy Turnbull still a part of this case? The guardian ad litem.
Ms. Turnbull, are you on the line today?
I am, Your Honor.
Are you
Yeah.
still a part of the case?
I don't recall if I've been discharged or not.
I was just
I-
looking at, it looks like there was an order appointing guardian ad litem back in September of 2022. And other than that, I don't see any later in time documents. Let me see what the order says as far as discharge of the GAL. So the order, it says the appointment ends when the GAL and will be discharged by the court if the final parenting plan is signed by the court, parenting is decided or other, and nothing is indicated. So there's no indication of when the appointment ends. So my indication, I think at this time, it looks like Ms. Turnbull is still assigned to the case, probably hasn't been active in the case for a long time.
It's
That's
it's
correct.
been it's been a little while.
Yeah. Okay, any other questions?
No, that is it.
Okay. Okay, so we will come back on March 13th. Mr. Ruby, make sure you quickly get those documents served to Ms. Granzo, pardon me. And then Ms. Granzo, if you have a responsive response, please get those filed and serve copies on Mr. Ruby.
Absolutely. Thank you.
Okay. All right, we'll see everybody on March 13th. If James Perkins, if you're here on the line, please state your name.
Yes, Your Honor. James is on the line.
Great, welcome to you, Mr. Perkins. Tanya
Thank you.
Skelton, are you on the line?
Yes, sir, I am.
Great, welcome to you also. And do you go by Ms. Johnson now?
Yes, I do.
Great, thank you. So let me just note that here. So we have Mr. Perkins and Ms. Johnson, and I see that Mr. Keith Lawrence, the guardian ad litem, is present. Can you hear me okay?
Yes.
Okay, great. So this is a review hearing. So from procedurally, it looks like there's a hearing end of November 29th of 2023. The court therein issued a temporary parenting plan and a temporary family law order, and the court ordered that either party could move to finalize the parenting plan. Since that time, I looked in the file to see if any motions had been filed. I did not see any motions being filed. And so I'm just not clear what the purpose of today's hearing is. And so maybe Mr. Lawrence, I could hear from you first, and then Mr. Perkins and Ms. Johnson after.
Your Honor, there had been some contention between Mr. Perkins and Ms. Johnson about Ms. Johnson's stability. And at one point, Ms. Johnson and her new husband had moved to Texas, which created a real difficulty for Ms. Johnson in seeing their son. And so she ended up moving back into the state of Washington, particularly in Vancouver. Mr. Perkins lives in I believe it's Wilsonville, Oregon. So they're relatively close now. And I had made recommendations essentially setting this up as a 50-50. And so I contacted both parties yesterday, and I'll let the parties speak for themselves, but apparently the visitation and the cooperation between the two has greatly improved, and they are co-parenting, and Clayton, their son, is doing very well.
Thank you, Mr. Lawrence. I appreciate that succinct summary. Mr. Perkins, your input?
Yes, Your Honor. Yes, we have, since the last hearing and this temporary parenting plan, Ms. Johnson has moved back to Washington in Vancouver. I have moved to Vancouver as well as of December 1st. We have been following the plan. Everything has been going well. The stability on Ms. Johnson's part has improved. And we have been in communication regularly about what we want to do and how we want to move forward. So at this time, we both have come to the decision that we would like this matter to be moved out of the court system, and all motions and all paperwork that's been filed be dismissed or closed out, and we move forward with Clayton on our own.
Okay. All right. Thank you, Mr. Perkins. Ms. Johnson, what's your input?
Yeah, I feel the same way, Your Honor. James and I have agreed upon everything as far as Clayton goes. All decisions have been mutual. We've been getting along great as far as drop-offs and pickups, and medical doctor appointments have been going great. Decisions as far as his medical concerns. We would like the courts to dismiss any of the temporary parenting plans that we have in place, and James and I would like to do this between ourselves now.
Okay. All right, thank you. Well, first off, just accommodations and kudos to both of you for working together for the best interest of your child. That's really great to hear. What couple things to consider it sounds like you're ready for the case to be done. Sometimes couples who have separated and have children in common, things go very well for a period of time, and then sometimes there's a snag in the road or an obstacle, and it causes some upset and some difficulty that is sometimes well solutioned if there's a parenting plan in place that the parties have agreed upon previously, that, this is kind of the base level. If, we can continue to work well together, but if there ever comes, push comes to shove and that we can't there's a dispute or disagreement, then there's that parenting plan in place, which can provide some guidance. So it sounds like you're ready for the court to not be involved in your lives. And so if you want to do that, one consideration is filing an agreed final parenting plan. That way that, you continue on with your good cooperation. If ever in the future there becomes some sticking points, then you would have that guiding document to kind of help you get over that without having to come back to court and incur new filing fees and the like. So that's one consideration. The other option would be a trial, and it sounds like no need for a trial. And the other option is if you dismiss the case, then the case is dismissed and there are no court orders. There's zero guidance. So let me just let that digest for a second and then just ask Mr. Perkins of what your thoughts are related to those options.
Yes, Your Honor. We've moved forward with an agreement or a parenting plan that her and I intend to follow. We can look down as far as filing that officially down the road. But taking this parenting class and really taking to heart the key point of not having as little outside influence into our lives and our son's lives has led us to the decision that we don't want to be coming to court every time somebody wants to bring up a change or has a disagreement. We agree that we want to exhaust all civil options amongst ourselves before we take the legal route.
Yeah, that makes sense. I mean, you two are in the best position to make decisions for the well-being of your child, rather than having a third-party court or judge or government official come in and make a decision. One thing to consider is that the parties brought the dispute to the court, and so at this point it's an open case. And so I guess one of two things needs to happen: either that there's an agreed final parenting plan that you put down and put it in, and so that makes it final, and that's kind of the base document. And what I tell people is that, if that's the base document, and if both parties agree that, not following that for a period of time and having the freedom and to adjust to the needs of your child, if you both agree to it, fine, that works great, and that's best for the child, and that's what should occur. But if there's ever a dispute and there's a sticking point, then at least there's a document that says this is what we need to do, and then you don't have to come back to court. But if there's a dispute on that, then you would at least have a means to resolve the dispute short of coming to court. And if both parties are still at disagreement, then you could come back to court and say, hey, look, this final parenting plan wasn't being followed. But the final parenting plan, if you do submit it as an agreed form, it provides that flexibility to take care of your child in the way you deem best. And if there's ever a disagreement, then you have that base underlying document that said, okay, this is our base situation. And if that doesn't resolve it, then you could come back to court and say, hey, look, this is what the parenting plan says. So Ms. Johnson, what are your thoughts about that as far as either dismissal or final parenting plan?
I agree with James. We have agreed upon everything so far. We haven't had any disagreements. I agree with you also. I mean, we can do something between him and I as far as putting something in play for a final agreement, but that can be later down the road, after we get everything worked out. But I mean, as far as right now, we can do a dismissal or whatever we need to do. I mean, we don't need to keep the temporary parenting plan in place. I mean, we've come to a decision with Clayton very peacefully anytime anything's come up. I mean, kept everything fair as far as visits go. Come to an agreement if there's anything that arises.
Okay. Yeah, that's fantastic. I appreciate that from both parties. Mr. Lawrence, any final thoughts?
Well, I certainly understand the logic behind having a parenting plan in place in order to fall back on it. It sounds to me as though both parties here are wanting to get away from the court system at this point. And I have no objections to that, Your Honor, and I wish them all the luck in the world. And if there's anything that we can do in the future to help resolve something, I'm more than willing to be involved again.
Great. Thank you, Mr. Lawrence. So I guess at this point, if it sounds like the parties are working well together and don't want to have any more court involvement, if that's the case, I would ask that the parties sign an agreed dismissal order. If that's the route you want to go, the other option would be to sign a final parenting plan and submit that. Which of those sounds best to you, Mr. Perkins?
I am in agreement to sign the dismissal order.
Okay. And Ms. Johnson, what do you think?
For now, we'll do the dismissal order.
Okay. All right. And so if that's the agreement between the parties to dismiss the action, the next step is I could draft a brief order that says, based on the agreement of the parties made here in open court, the cause is hereby dismissed without prejudice. That means that if you need to come back in, then you can come back in. So would the parties be comfortable if I were to create that document and forward it to you, and so you know what it says?
Yes, Your Honor, that's agreeable by me.
Okay, Ms. Johnson.
Yes, Your Honor.
Okay, let me just jot myself a quick little note here. And as far as getting that order to you, if I were to forward it to Mr. Lawrence, Mr. Lawrence, do you have both email addresses of Mr. Perkins and Ms. Johnson?
I do.
Okay. Would you be comfortable in forwarding that order to them?
Sure.
Okay. All right. Does that sound okay to you, Mr. Perkins?
Yes, Your Honor.
Okay. Ms. Johnson, are you okay with that too?
Yes, Your Honor.
All right. I will prep that and get that out to Mr. Lawrence. Likely midday today. If not, then it'll be no later than tomorrow afternoon.
Thank you, Your Honor.
Okay, great. So we'll get that. And so just based on the verbal agreement between the parties, I'm just verbally dismissing the order without prejudice, and then I'll follow that up with the order of dismissal that I'll forward to Mr. Lawrence, and then so you'll both be able to see that.
Thank you, Your Honor.
All right. Any final questions?
Thank you. No questions. I would like to thank Mr. Lawrence for everything that he's done with all the hearings up to this point.
Great. Thank you.
Yeah, no other questions. Thank you, Mr. Lawrence.
Thank you, guys.
Okay. All right. That'll conclude that hearing. Thank you.
Yes, I am, Your Honor.
Thank you, Your Honor.
Okay. Welcome, sir. Kathy Geidel,
Thank you.
on the line. Kathy Geidel.
Yes, I'm on the line.
Okay. Very good. Welcome to you, ma'am. All right. So we're here for a review to see if Mr. Geidel had paid the contempt sanction, and I'll turn to Ms. Geidel to see if you've received those funds. Ms. Geidel?
Yes, no, they were to be handed into the court.
Oh, I apologize. I didn't hear clearly. Could you repeat that?
Yes, the funds were to be handed into the court.
Okay. And Mr. Geidel, did you submit those funds to the court?
Yes, I did, Your Honor.
Okay. So what date did you do that, sir?
On the 12th of February, sir.
12th of February. And what was the amount that you submitted?
The full amount,
Do you recall the amount?
$2,500, sir.
Okay. Thank you, Mr. Geidel. Madam Clerk, I don't see a notation in the file. Would there be some notation from the accountant in the office? Okay. The clerk is taking a moment just to look at the financial aspect of the file. Okay. So the clerk confirmed that Mr. Geidel did in fact submit that payment, and then the clerk indicated she wasn't quite sure what the process is for those funds to be dispersed to Ms. Geidel. So I'm not sure either. So I'm just trying to think through this. If they're new,
Could I offer some suggestions?
that last part of your statement, it didn't come through clearly. Could you repeat that?
Yes, could I maybe offer a couple of suggestions?
Yes, please.
Yeah, I do have a friend who has, prior put in all of my paperwork, etc. I could arrange through her to have it picked up and forwarded to me. Otherwise, I could call the courts and give my banking details, or it could be sent via slow mail. But being that this has gone on since 2010, I would quite like to get the pittance of what I was allocated.
Right.
Rather quickly.
Right. Okay, maybe what we can do, it looks like the clerk is sending out a quick message to the financial person in the office. Would the usually the financial person is pretty prompt in replying to emails. Would the parties be willing to just wait maybe while I call one or two cases and recall this case and then review that email from the financial person to what the process is?
Yep, that's fine by me.
Okay. And Mr. Guido, as far as, you've complied with the court ordered, so I don't have any issues if you want to sign off, because at this point in time, you've complied with what the court ordered, and now it's just a kind of a perfunctory administrative efforts to get those funds to Ms. Guidel. So if you want to stay on, you're more than welcome to stay on. If you have other things to do, you're free to go also. I don't think it'll take us too long to get to it, probably tops 15 minutes.
Thank you, Your Honor. I'll sign off now.
Okay. All right. Very good. All right. So Ms. Guidel, why don't you hold tight? We'll get the response back from the clerk, financial person, then we'll give you an updated about how those funds can be dispersed to you.
Thank you.
We need an order that specifically orders it to be dispersed to them, and then we need her address.
Oh, okay. Ms. Guido, looks like we got the response back. That was quick. I appreciate that. It says that the clerk says that they need an order from the court dispersing those funds to you, and an address at where it can be mailed.
Okay. Yes, that's fine.
So I'll take care of the order. I'll draft that and then get that to the clerk. And then the address I show, maybe you could tell me the address and I'll just compare it to what I have on file.
Yeah, sure. Correct.
Perfect. I'll include that in the order so there's no ambiguity or question for the clerk. That order will be submitted either today or at latest tomorrow afternoon. And then, a day or two of processing. So I would assume by the end of the week that check's going out.
Thank you. Your Honor, could I just make a mention, please?
Sure.
I am so disappointed about the outcome of this.
Mm-hmm.
We went to court 4 times, and every single time the contempt orders, he was told by yourself that he needed to pay me. 4 times, he totally ignored that. Never once in that whole time did you put in there that if he did not pay it, he would face jail until the 10-year period. We had 2 more contempts, one in 2017, one in 2018. And I just feel the court has totally done the wrong thing by me. He walks free now. After 13 years, he walks free with only having to pay $2,500. And I just feel totally deflated by this.
Yeah, Ms. Andrews, I appreciate that input and feedback. Certainly, the court's sympathetic to the position that you've been put in by Mr. Guido's failure to follow through with the order. The court's order from January of this year indicated that the court made a finding of Mr. Guido being in contempt for not making payments towards that $7,200 judgment. That judgment was recorded in August of 2013. And in 2017, the court adjusted that payment amount that he was making monthly payments, and said
But
it
he
at
didn't. He
50 per
wasn't.
month. Right? Yeah, he failed to do that.
He never had. Not
and then-
once. Not once. In all the times we've been back to court, not once did he pay.
Correct. Correct.
And then,
And then he made a motion to suspend that $450 payment, and the court reduced it to $200 a month for 2 months, and then returning back to $450 per month. And he never
still didn't pay it.
He never made a payment, and he violated the court order to do so. And so the court imposed that civil fine of $2,500, and he paid that. And also, what's important is that the original order was it needs to be renewed. So a judgment is in place for 10 years, and then if you want to go beyond 10 years to collect on it, then you need to renew that judgment, and that judgment was never renewed prior to August of 2023. And notwithstanding that he on the docket and made rulings on the docket related to that, there's still that one piece that was missing, which is that renewal of the judgment. And without a renewed judgment, by its terms, the judgment of $7,200 expired in August of 2023. And so, like
I appreciate that, but at no stage was I aware of it. And being that I live in a different country, different rules, nobody could help me. Couldn't get any help from here because you guys are in America, different rules. It's just like, it's so unfair. So unfair. I had booked a trip to go back to America to fight this in court, and it would have been prior to, but then COVID hit. Subsequent to that, I then broke my back. So it means I can't travel anymore. It's just like, I'm just devastated, to be honest.
Understandable, Ms. Kettle. And like I said before, your situation is very sympathetic, and yet the court has to follow the particular rules. And like you said, living in a different country, different rules and the like, it makes it very challenging, especially when you're not a lawyer and you're not familiar with the different rules. So at this point, you know, your potential options are to file an appeal. If you feel like the court made an error or made the incorrect decision, you could file an appeal. Other than that, that would be pretty much your remedy or option at this point. And so I appreciate the feedback, and I appreciate the hardship and the difficulties that you've encountered. And I also appreciate the fact that the law requires certain things that sometimes are hard to stomach.
I appreciate that too. I guess I just needed to be able to vent that.
It's important. I agree. All right. With that, I'll make sure that order is prepared and submitted, and that those monies will be dispersed to you.
Thank you, Your Honor, and hopefully we never have to meet again.
All right. Take care. Okay. So this is Ms. Keel's motion for contempt related to child support. So let me just first, before we get started with kind of the substance of the motion, Ms. Keel, as far as the service of the documents upon Mr. Huff, I see declaration of service that was filed on February 9th that indicates that Karina Hamilton served by alternative means to Mr. Huff the following documents: an order to go to court for contempt. So that's the document that was served upon Mr. Huff, and I'm curious to know if you served any other documents, including the motion and your declaration of supporting your motion. Were those documents served? Because right now it looks like they were not.
Yes, they were. I believe Karina, when she filled it out, probably missed checking those boxes, but she had the whole packet.
Okay. So, okay, I appreciate that. So according to, the file and the paperwork that's been filed, only one document was served upon Mr. Huff, which was the order to go to court for contempt, none of the underlying documents. So with that being the case, let me check with Mr. Huff. There's a couple of ways we can approach this. Technically you haven't been served, and so we're not in a position to go forward today if you didn't receive those documents. Sometimes people don't want to come back to court again, and if they actually have received the documents, they can waive that service requirement and proceed today. So just want to touch base to see what you want to do.
So there's other documents that were missing? Is that correct? Is that what I'm hearing, Your Honor?
As far as documents missing, no. What is shown is that what's required is that any document that is part of or relates to Ms. Keel's motion has to be served upon you so you know exactly what she's saying and you have an opportunity to respond.
I did respond, Your Honor. You should have a packet, and then I did serve her too the same packet.
Right. Yeah. I see that you submitted your, and I reviewed that. So there's still that issue of service. According to the technical reading of that declaration of service, you weren't properly served all of the documents. So one remedy is to continue the matter, have you reserved, and have the declaration of service updated to show that all the documents were served upon you. That's one option. The other option is for you to waive the requirement for service for the technical service and just proceed today, because it sounds like you've received the documents and you've responded.
Yes, Your Honor, we can proceed.
Very good. We'll proceed then. So I'll hear from Ms. Keel first as to the motion, and then we'll hear from Mr. Huff. Ms. Keel?
Okay. So I filed the motion because for the last basically the better half of 6 years, he doesn't pay child support. He owes me $11,600 and something right now in back child support. I do see I called my Washington State child support enforcement officer, and she was unaware of any agreement that Oregon had. But I do see, even based off of the paperwork for his quote unquote compliance agreement with the state of Oregon, he is also in contempt of that agreement, because it says he agrees to pay $300 by the 18th day of each month beginning 12/18/2023. Well, the paperwork that I provided to you also shows that those payments, they were coming late. But not just that, we're now at 1/29 or 2/28/2024, and I never received his $300 payment on the 18th of the month, and the agreement is no longer in effect as of 2/20/2024, and I still have yet to receive any payments from him. But before this agreement was even made with the Division of Child Support on 12/18/2023, you could see that there was 0 payments made in September, 0 payments made in October, July, June, May, February of 2023, the first month of 2023, December, November, October of 2022. Then again, he was only making partial payments for September, August, July, no payment at all in May. So he's just, historically, he doesn't pay his child support. He goes on vacations. He's clearly making money. He's got toys. His declaration, I don't know, because I was unable to get a bench copy to you yesterday. I did overnight paperwork to Ryan, a response. But his sob story of he was in an accident that turned his life upside down. He was in an accident that took somebody's life because he was drinking and driving. And he also hurt a passenger in the vehicle. He lost his job because he was misusing company cell phones, harassing his ex-girlfriend, flipping her off. And that was like back in 2021. So that would have no effect on the lack of child support payments in 2022 and 2023. He says he started his company in 2023, but he also, the Facebook post that I provide state as of December 2nd, 2023, he'd been in business for 1.5 years. He says he's got contracts with U-Haul, crane companies, tow companies, Tidewater Fleet, all these companies, but he can't pay $646 a month for a child that he created. He goes bankrupt. Then he posts on Facebook he's looking for a vehicle in the amount of $25,000 because he quote unquote misses having an Evo. He's got multiple vehicles. So like, you don't get to buy toys and own toys and have toys when you're going bankrupt because you can't pay your bills and pay your child support. And again, he's in contempt because he had an order stating that he needed to pay his agreement that he made with the state of Oregon doesn't cover all those other months that I brought up. I just didn't want to go to court and deal with anything, but it's gotten out of hand at this point when I see how busy he is with his company and all the money that he's making and bragging about it on Facebook, but then he can't even pay the $300 that he agreed to pay for the month of February.
Ms. Gill,
And
can I ask a quick question?
yes.
Just so I'm clear, there's two court orders related to child support in this case. One is from March of 2018 that orders Mr. Huff to pay $441 per month. That order was amended in March of 2023, starting in February of 2023, that reduced the amount to $331 per month. That's the court orders. As far as administrative orders, I don't enforce those. If there's a contempt, it has to be on one of those two orders, either the $441 per month or the $331 per month. Is that your contempt?
The court order also states that he's responsible for paying, reimbursing me the child care that I pay for Talon.
Were you making that claim? Did you make that claim in your motion for contempt? I don't remember seeing that.
I added it in the total amount owed.
Was that included in your motion?
Should be, yes.
So
I
it
don't have
indicated
the
that Ryan has not been paying child support, although he's working full-time and running his company. See attached declaration. So I'm a little bit confused, and so that's why I'm asking the question. In your motion, you say the past due amount is $10,256 from 2022 to 2024. No specific dates, just years. And then there's a current month of $646. I don't know where that $646 dollar amount is coming from, because the court order either is 441 from 18 or until 23, and then it's from February of 23, it's 331 per month. So I'm not sure where that 646 is coming from.
Because they had me fill out the childcare stuff, and so they grouped that in because it's reimbursement.
Do you specify that anywhere within your declaration?
I honestly don't remember. I did everything by myself.
Okay. All right. And so you filed a declaration, it looks yesterday. I prepared my docket prior to yesterday, so I'm just looking at that now for the first time. And it has some attachments to them. And I'll ask if Mr. Huff received that declaration that was filed by Ms. Kill yesterday on the 27th of February.
I have not received anything, Your Honor.
Okay. So in that document, it has her declaration. She makes a page and a half of a declaration. Then she includes a State of Washington Division of Child Support printout generated on February 14th of this year. It gives a month-by-month listing. It shows the month, the order amount, the amount paid, the monthly debt, and the running balance. And I think that's where Ms. Kill is indicating that $11,248 is the amount owed. In particular, it's showing non-payment in the months of October, November, December of 2022, January and February of 2023, May, June, July, August of 2023, and also September of 2023, no payments. And then showing $250 payments for October, November, December of 23, a $300 payment in January, and as of February 14th, no payment for February. So that's a document that you haven't seen.
Okay, Your Honor, I
It's a
understand.
document he provided as well. It's just a shortened version because he provided his Oregon order for his other child he doesn't pay child support for, and then grouped in mine as well.
So the Oregon and Washington orders, I have zero authority to look at the Oregon, make any enforcement action or contempt findings related to Oregon. Correct? I have zero authority to do anything with the Oregon, correct?
That's not my child.
Okay. So yeah, so we're not dealing with Oregon. We're dealing with.
But I was just saying he has the other additional document that I did provide is a document that he provided in his declaration. It's just a condensed version rather than having all of it.
I'm looking at Mr. Huff's documents, and I see only an Oregon document that lists month child support amount and child support paid. I don't see any Washington.
The one that I have says month by month summary, and then it says Ryan Huff and Clarissa Keel, and then it says state of Oregon, but that is a Washington. The other jurisdiction underneath that says Washington. That is actually the Washington order. But because he wasn't paying and they couldn't, like Washington couldn't find him, Washington had to reach out to Oregon and get Oregon involved because he's an Oregon resident.
Okay.
So, but what I was saying was my version is the same as his. He has seen the same numbers that I provided in his own printout that he provided to me. It's just Washington's printout instead of Oregon's printout, but all the numbers match.
Okay, I see what you're saying. Yeah, I double checked there, they appear to be similar. So, so I guess I need to know from you, Ms. Kill, what are the specific dates, months then that you alleged no child support was received or less than full amount was received?
Well, there was 5. So 2022, so January 2022, only 143 was paid of the order. May 2022, 0 was paid. 6 of 2022, 418 was paid. And then 9 2022, 143 was paid. 10 2022, 0. 11 2022, 0. 12 2022, 0. 1 2023, 0. 2 2023, 0. 5 2023, 0. 6 2023, 0. 7 2023, 0. 8 2023, 0. 9 2023, 0. And then in December, I know this is petty, but he did have an agreement that said he was supposed to pay $300 a month starting in the month of December, and he only paid $250.
Okay, any other months that you claim non-payment?
I mean, I didn't add in like 2021. I believe I only started from 2022. But I mean, there's some from 2021 as well. But I just wanted to focus on the last 2 years because it's already too much.
So in 2023, starting in February, the dollar amount of payment was $331 per month.
Mm-hmm.
And when I look at February of 2023, the amount paid is he paid $3,683 in April, $1,743 in May, $250 in October, November, and December. And it shows a yearly total paid of $6,176. And
he had a continuous running debt.
So if he's required to pay $331 per month, you multiply by that by 12. 1 second. Hasn't he paid that full amount? Or am I missing something?
Well, that's balance carried from previous years. So it's my understanding that just because you're paying off a previous month doesn't mean that you don't have to pay your current months.
So the court order here, the court order is that he pays $331 per month. It doesn't specify where those monies go, if it goes for arrears or if it goes for current. The order says $331 per month. Is that the way you read that order? I'm looking at the March 2023 order.
I suppose you would know better than me on how to understand it.
So I'm just looking at that order and I'm just going to pull it up. It says Ryan Daniel Huff must pay child support to Calissa Rose Kiel each month as follows for the child listed below. Talon $331 per month. Start date February 23, due on the first of each month. Payment method, enforcement, end date, tax issues, medical support, health coverage, children's expenses, past due child support. It says that the order does not address any past due amounts or interest owed. Any unpaid support owed by any parent under a court or administrative order is still due and is not changed or canceled by this order. So it looks like the straight obligation is $331 per month as of February 23.
And he still wasn't even doing that. because in February of 2023 there was zero payment. So wouldn't, from my understanding of the order and from the way that the child support enforcement officer told me, was each month he should still, no matter what, be paying the balance that is due.
Yeah, the order is that he pays $331 per month per the child support order.
Mm-hmm.
Okay, so let me hear from Mr. Huff.
I'm in compliance with Washington and Oregon, Your Honor, right now. Oregon actually has all my financial documentation. This was yes, I am working and I'm trying to get back on track. I did start a business a year ago. I haven't even done my taxes yet this year, Your Honor.
Let me ask you, so when you pay child support, do you send it to the Division of Child Support or the Support Enforcement Office?
Yes, I do have Oregon. And Oregon disperses the funds.
Okay, so you send it to Oregon and then they send it out.
That's correct. They send it to Washington and then she receives it.
So I'm looking at the printout. So it looks like in the month of January of 2024, you paid $300. Does that sound right?
That is correct. I have an order I've been for the last 6 months on order plan from Oregon.
Okay, and you understand that Oregon can do whatever they want, but it doesn't affect the Washington state order, correct?
That is correct.
Okay, and then it shows in December of 23, you paid $250.
That's correct for my order in Washington, or for my order in Oregon.
Okay, and then in November and October, $250. And so in those months, $331 was required, but $250 was
correct.
Okay. And then in the months from May 2023 to September of 2023, it shows that there was no payment made. Do you agree with that or disagree with that?
Oh, I agree with that, Your Honor, 100%.
Okay. And then October of 22 through February of 2023, it shows $0 payments.
Correct.
And then in March of 2023, there's a $2,900 payment.
Correct.
And then in April, there was a $707 payment.
Correct.
Okay. And so what is your position? The court order requires monthly payments. Here that there's absence of monthly payments and they kind of have these big hits and then some under dollar payments being made. So tell me your position.
I started my business and it's up and down, Your Honor. I'm a first-year business owner. So some months I could pay a lot and other months I can't. I saw depending on work and workload. Okay.
Yeah, I recognize that there's ups and downs with business, especially when you're starting, and yet the needs of children are fairly consistent. And so if the court orders X number of dollars to be paid each month, and Ms. Hill is saying that you haven't complied with that.
I've been complying with Oregon. Oregon has all my bank records for my business and my personal account.
Okay. So tell me why I should care about Oregon when we're talking about a Washington order.
Because I've been in contact with Washington Child Support too, and they are not coming after me. I've been in contact with my child support of Washington and Oregon. Oregon is taking over for Washington.
Your Honor, can I say something? When I spoke to our child support case enforcement officer, Tara Howe, she claimed she was completely unaware of this Oregon order, and didn't know why that Oregon would step in, because all they're supposed to do is mediate and collect the money from him. They're not supposed to change anything, because what I was told is it's a Washington order. Washington has jurisdiction over the child support and the child, and it seems that his other child support enforcement officer for his child in Oregon intermixed the two so he wouldn't lose his license. But that, not losing your license doesn't change your financial obligation each month. It sounds like that was just an agreement with Oregon to keep his license, but it doesn't change any of the other orders. But again, before he was even quote unquote in compliance with Oregon, there's all those other months that nothing was done. I shouldn't have to take him to court and fill out a bunch of paperwork and force him to pay child support. He knows his obligation. And I mean, he's clearly bragging.
I was in and out of, Your Honor, I was in and out of jail for 7 months.
That's a personal problem.
So hold on. Let me tell you what I'm doing. The difficulties we sometimes run in with self-represented litigants, that you don't do this on a regular basis, and so it requires a little extra work from the court to understand what's happening and to make some calculations of what's required here. So the allegation is that from 2022 to 2024, Mr. Huff has failed to pay child support, and therefore he's in contempt of the order that requires him to pay that. So in 2022, the existing order required $441 a month of child support. So if you multiply that by 12, that's $5,292 for the year of January through December of 2022. Now, Mr. Huff during 2022 paid the following amounts, and I just have to calculate that: $143.65 in January, $574.59 in February, $2,543 in March, $943.68 in April, $418.69 in June, $841.73 in July. And hold on a second. I've just got to hit the numbers and not speak when I'm doing it. Just a moment. So through September, Mr. Huff of 2022 had paid $5,818.34, which was more than the required amount. Then in October, November, December of 2022 through January and February of 2023, there was no payments. So that we know in February of 2023, that's when the new order went in effect at $331. So let me calculate those numbers. One moment. For 2023, what he's paid. So what I calculate, if you have 11 months in 2023 at $331, that's $3,641 that's required. And according to the printouts that both parties supplied, Mr. Huff has paid $4,433.85 for the calendar year 2023 starting in February. So he's overpaid there. So where it becomes tricky is that, so it's showing that he's meeting his obligation, but he's not paying it on a monthly basis as required by the court order. So on one hand, is he in contempt for not paying the child support? No, he's paid more than he's required to under the court order. However, there's the requirement under the court order that each monthly payment is submitted by the first of each month. So is he technically in contempt? Yes. So that's kind of where I'm at. So I'll hear from the parties and just hear your final comments. I'll hear first from Ms. Kill and Mr. Huff thereafter.
I mean, you kind of hit the nail on the head, Your Honor, in the very beginning when you said, like, a child's needs don't just stop each month. And each month I have to feed him, clothe him, provide transportation to and from appointments, drive him to school because he's too young to walk home from school. He's in sports monthly. He does all sorts of extracurricular activities, and I can never rely on child support from Ryan. And sometimes I have to work extra. I have to borrow money from friends, family. I put money on credit cards, which then in turn I'm paying interest on credit cards because there's extended amount of times where I'm not receiving that money that is required from him by the first of each month. Yeah, it's great getting those large amounts, but by then, like, we've already suffered. We've already went through our struggles and, just having to tell your kid no to certain things because you don't have the money for it. Because no matter what, I still have to pay for childcare. I still have to pay for all of those things. I can't just not pay for things for him. And yes, he's paid over his obligated amount, but that's because he's not meeting it every other month. He constantly has a running balance. He owes me almost he owes me over $11,000 at this point. And that's not.
All right. Thank you, Ms. Gill. I think I have a fairly clear idea of what your position is. Mr. Huff?
I am going to be paying the full. I be this month and the following, I'm going to be complying, Your Honor.
Okay. All right. So I think I appreciate the parties providing your input and perspective, and the documents are really helpful. So it looks like, the order in 2018 required a payment of $441. And then starting February of 2023, the amount was changed to $331. So for that time period through January of 2022 through September, he had already paid $5,800, which was about $600, $500 more than required, but they were intermittent, not consistent on a monthly first of the month basis. Through 2023, the 11 months through February through the end of the year, he had overpaid roughly for $800, but they were not timely on a monthly basis. So I'll make a finding of contempt for not paying on the first of the month. But overall, he's satisfied that the dollar amounts required by the court order. I'll impose a $100 civil fee, and that Mr. Huff, you can purge the contempt, or basically set it at naught by paying on the first of each month the child support amount of $331 for 9 consecutive months. If you do that, then the contempt finding is purged. So that'll be the order of the court. So let me double check with Ms. Hill to see. I'm just looking for a proposed order that you may have submitted.
The proposed order would probably have to be greatly changed just based off of the numbers, Your Honor.
Yeah, it will. So what I'll do is that I'll have to review that particular order and make some adjustments to it. And then I'll get that filed. And basically, again, what that will be a finding of contempt for a lack of payment on the first of each month, a $100 civil fine, and a purge condition by Mr. Huff paying on the first of each month for 9 consecutive months.
Yes, Your Honor. And just to clarify, so if I want to address the unpaid child care portion, I would have to bring a separate motion.
The first step you need to take a look at, one option you need to look at, is whether there is a court order related to daycare or child.
It covers a percentage, but not an exact amount, Your Honor.
Yeah. Yeah. So any future issues, either party can file that if you feel that there's been non-compliance with a court order. So at this point, I'll make sure that order is filed by close of business tomorrow, and I'll ask if any party has any questions. Mr. Huff, do you have any questions?
No, I don't, Your Honor.
Okay. Ms. Gill, any questions?
No, I don't, Your Honor. Thank you so much for your time.
Okay. That'll conclude the matter. Corey is present, the guardian ad litem. Mr. Kudlicek, are you on the line?
Yes.
Okay. Welcome to you, sir. And Ms. Knowles, are you on the line?
Yes.
Okay. Welcome to you, Ms. Knowles. We're here today for a review. So I didn't see any updates filed by Ms. Corey. So let me just maybe start with Ms. Corey and tell me where we're at.
Thank you, Your Honor. I've had some difficulty in this case being in contact with Ms. Knowles. I have tried very hard to reach her, and she hasn't responded, or has responded in a way that's very difficult to understand. I was hoping that to hear that she had complied with some of the orders from the last hearing and be able to include those things in my report. I received no response back from her, and I do have some newer information that I wanted to include in my report, and would like to respectfully ask for a 2 to 3 more weeks on this.
Okay. All right. Thank you. Let me touch base with Ms. Knowles. Ms. Knowles, it looks like on January 3rd, the court ordered you to get several evaluations, including a domestic violence, mental health, and substance use disorder. Where do you stand with that order?
My doctor has put in a referral, and I had one last week, and I'm waiting for the rest. I haven't reached out because I have no working phone. I work graveyards, and my life's, I reached the people for supervised visits. No one has reached back to me. AZA doesn't answer me. I mean, I'm doing what it's asked, but I'm still, it's a battle still.
Which evaluation did you complete?
I think the domestic violence or substance. I can't exactly remember which one it is. I hope I can email you or let Ms. Corey know, because I'm currently not at home.
Okay. And as far as the mental health evaluation with the parental risk assessment, where do you stand on that?
I'm just waiting for my appointment.
Okay. When's that set for?
I think it's the 17th of March.
Okay. And then the other evaluation, the SUD, substance use disorder.
I think I did 2 and 1. That one might have been completed as well.
Okay. And have you received any the results of those evaluations with any recommendations?
No, I haven't received no paperwork or anything yet.
Okay. All right. Thank you. Okay. So Ms. Corey had indicated that she has some new information that she'd like the case continued for roughly 2 to 3 weeks so that she can update the court with new information that she has. Mr. Kudlicek, do you have any input at this point?
No, Your Honor.
Okay. All right. Thank you. Ms. Knowles, any further input as far as the request from Ms. Corey to continue the matter 2 to 3 weeks so she can submit a report and everybody can look at it and talk about it?
I mean, I have no issue, but I would like to get my visits.
Okay. Yeah, the residential time from the court order of January 3rd, Ms. Knowles has 2 hours for 1 time a week, and that's supervised, and also a midweek video visit for 30 minutes. So if you're having difficulty with the supervisor, I would encourage you to contact them again and maybe touch base with Ms. Corey. She may have some suggestions on how to better get that going. So with that said, let's come back on the 20th of March. March 20th, we'll come back to review specifically the guardian ad litem updated information report.
Well, while we're all here, can Miss Corey give me the information as well for a supervised visit center that she knows? Because I contacted one in Kalama, one in Woodland, and one in Kelso, but no one has reached back to me.
Yeah, I'll encourage the parties. You can communicate offline once we're not on court time. So the parties can certainly do that. So we'll come back on March 20th, and hopefully Ms. Knowles can get those visits arranged so she can have a residential time with the child.
So will I be having my visits on Wednesday and the weekend?
The court order is from January 3rd. It says 2 hours for 1 time a week supervised, and then a midweek video call for 30 minutes.
Well, is there any possibility to change that so she can have visitation with her brother as well?
So if you want to change a residential time order, you'd need to bring a motion and write it and submit it, and then Mr. Kudlicek would have an opportunity to respond to it, and then we'd have a hearing on it. So if you want to change that order, certainly you could bring a motion to change that, but you'd have to first file the motion, then serve a copy to Mr. Kudlicek and also Ms. Corey, note it up for a docket, and then we could hear it.
Okay.
So we'll be back on March 20th at 9 a.m.
Thank you.
That'll conclude the hearing. Thank you, ma'am.
All right. Thank you, Your Honor.
Brandon Lovato, are you on the line?
Yes, Your Honor.
Okay, welcome, sir. As far as today's matter, this is a motion brought by Ms. Lovato to reinstate child support. First question I wanted to touch base with Ms. Lovato. As far as the service, that I show a declaration of, let's see, let me pull it up. Declaration of, sorry, one moment. Ms. Lovato, as far as you submitted documents related to the motion for the motion to reinstate child support, and did you serve those documents upon Mr. Lovato?
Yeah, so we've just been doing everything over email for service and stuff since this whole thing started. So I just emailed it to him, and then he already told me that he already had went to the court website, I guess, to look at the forms.
And once you emailed those documents to him, did you submit what they call a declaration or affidavit of service saying, hey, on such and such a date, these documents were served upon Mr. Lovato?
I didn't, no.
Okay. So one thing to keep in mind is that the rule of service requires that anytime that documents are served upon another party, the parties cannot serve the other parties that document. So you'd have to have a third party serve those documents upon him, and then have them file what's called a declaration or affidavit of service saying on such and such a date, I served these documents upon person X, and it gives a listing of the documents that were served. So there's a couple ways we can approach this. Generally, service is really kind of, it's viewed pretty tightly in that the court generally requires service to be effectuated properly. It's a slippery slope when we start saying, okay, well, even though it didn't happen, let's move forward with it. Then the rule becomes meaningless. So there's 2 approaches. One is that we come back at a different time after Ms. Lovato has properly served Mr. Lovato, and there's been a declaration of service filed. And then that's one option. Then we'd come back at a later date to hear the motion. The other option is that Mr. Lovato waives the right to be properly served and uphold that. And his waiver doesn't control the court, but it would take it in consideration. And if he waives the proper service, then we could proceed today. So I'll ask Mr. Lovato, do you have a preference?
I don't really see much of a reason, to push it off. The only thing is the documents I did receive was just the motion. There was no other documents really for the child support, including like the updated financial stuff, which is greatly different from what it was in March.
Sure. Okay, so the only document you received was just the actual motion where it says, "Hey,
yes, correct, Your Honor."
All right. So I think we need to default to the service rule. So any documents that serve as a basis or part of Ms. Lovato's motion, those would need to be served upon Mr. Lovato, and a declaration of service would need to be filed supporting that.
Okay, can we still just do it over the email since we've just been doing that? And then I just submit the proof of service like that?
Generally, the rule requires either personal service or via U.S. mail. And if the parties agree to email, sometimes it's a lot easier. That's fine. We just need to have that agreement on the record. So if the parties are doing that, then the parties would need to make that known. So, Mr. Lovato, do you have any feeling as far as electronic service versus U.S. mail or personal service?
We've been doing just fine with the electronic service for the most part.
Okay. So if I understand correctly, both parties are in agreement that when documents need to be served, both parties are agreeing that they can be served via email.
Yes, Your Honor.
Ms. Lovato?
Yes.
And I have a Shanice Watts. I won't say the whole thing, but that's the address, correct, Ms. Lovato?
Yes.
Okay. And then Mr. Lovato, what's just the first part, not the last part?
Yes, it's just.
Okay. And is that the one you've been using, Ms. Lovato?
Yes.
Yes.
Okay. All right. So the agreement is clear on the record that both parties agree to accept electronic service. So with that, the documents that serve as the basis for your motion to reinstate the child support, Ms. Lovato will need to serve those upon Mr. Lovato, so he has a full and complete picture. And then we'll probably need to look at coming back in 2 weeks, just in case Mr. Lovato wants to file a document in response, and that would also allow Ms. Lovato to reply to that responsive document. So I think we need to set the matter to March 15th at 9 a.m. I'll ask if both parties are available on that date to hear the motion to reinstate child support. Ms. Lovato?
You said the 19th?
13th, pardon me, March 13th.
Okay, perfect.
Okay, Mr. Lovato, March 13th, how does that look?
That should be no problem, Your Honor.
Okay.
And all the documents that I submitted everything to him. So do I like resubmit everything? Because I already gave him everything that I've submitted to the courts.
So any time that you serve a party, you need to serve them with all the documents that serve as a basis or a foundation for your motion. So even if you've previously served them, your declaration would need to show that you've served all of them.
Okay, because I think I've sent everything to him. Okay.
All right. So, and then once you've completed that, then you'll need to submit that declaration of service.
Okay, perfect.
All right. Any final questions, Mr. Lovato?
No, Your Honor.
All right. We'll reconvene on March 13th to hear the motion after service has been effectuated.
Okay, thank you.
Okay, we'll see everybody then. Ms. Rhodes' motion for temporary orders. And one thing I want to see is that looks like Mr. Jensen, you were served with those documents. Ms. Rhodes filed a document that says, hey, on such and such a date, these documents are served upon you. And then when I was preparing the docket, I didn't see that you had filed anything in response.
So I was looking through the papers and I did not see that paper that said I needed to. I've never done this before. And then I asked her about it on Friday while I was at her house. And she said that it's fine, that this is just a temporary thing. I didn't need to do it. So.
Okay. Did you plan to? So at this point, I know what Ms. Rhodes wants. I've read what she's proposed. And what's your position? Are you wanting the same thing that she wants, or do you want something different or tweaks to it? Something different. Okay. And so if you want something different, then your voice needs to be heard. So you'd need to file something with the court and then send Ms. Rhodes a copy of that document. So technically we're in a position where we would go forward today because she served you in a timely fashion.
Right.
And as a general rule, we try to make some allowance to allow both parties to have their voice heard. So it sounds like you want to respond, and I'll hear from Ms. Rhodes. So a response would necessarily delay today's hearing, and we'd have to come back at a later date to allow you to file that. And so she could read it, and if she wanted to file something in reply to your comments, then she'd have opportunity to do that. So Ms. Rhodes, do you have any comments on that?
So all I was hoping today was just that we would maybe move forward with my temporary requests and then get a guardian ad litem appointed. Then we could have them do the investigation and they could submit their recommendations to the court, and then we could maybe move forward from there. And I was also hoping to get whatever, as far as like financial support, I would like whatever is deemed necessary based on the child support worksheet. And then also 50% of childcare, which would be about $400 per month.
Okay.
So I was just thinking we would just go with the temporary, because what I asked for on the temporary is what me and him have been doing already as is. So then that would just give an opportunity for the guardian ad litem to interview with both of us. And then we could maybe discuss moving forward from there. And then that give him an opportunity to give his response.
All right. Thank you, Ms. Rhodes. So a couple of different things. I'm generally okay with an appointment of a guardian ad litem. And then that person gets on board and then would reach out to both of you, and then you'd send information back to him or her. And then they could start the process of doing their investigation and writing a report. That's generally a good idea to get that going earlier rather than later. And then as far as child support, I don't have in order to make a good decision about child support, because the concern is that if I enter a temporary order today, that becomes an order of the court. And I don't know the basis that Mr. Jensen is going to supply of what he feels the percentages should be or should not be. Certainly parties can agree to continue what they've been doing, and you can actually submit an order to the court and say that, hey, we agree to this, and the court can just sign off on it. But as a general rule, it's at least important for me to hear from both parties, to hear what your respective positions are when it comes to childcare, child support, and the like. Certainly if the parties have been doing something,
So he has
up until now.
He's given me only $350 in the last 2 months since he's gotten out of rehab.
Mhm.
So then that's the thing, is that I've been paying for everything. So I'm paying $800 a month for childcare. I'm paying for all the food, all of the transportation, I'm paying for her health insurance. So I would just like to have some sort of support on that. If there was a way we could even do where he's just giving me half of daycare until we get something else moved forward.
So theoretically, we would be coming back in roughly 2 weeks.
Okay.
So I think as far as the guardian ad litem order, let's talk about that, and then we can kind of come back to some of these things that then go perhaps to lift it up. So, Mr. Jensen, what is as far as the appointment of guardian ad litem, usually what we do, we keep a list, and then and they're kind of in a hierarchical order. Once somebody gets chosen, then they go off and then come back up to they go to the bottom of the list, and then they work their way up. So what we do is we tell you who the 3 next guardians ad litem are. And then if each one of you has the opportunity to strike one and say, I don't want that person to serve as a guardian ad litem. Most attorneys know the guardians ad litem. You probably don't know the guardians ad litem. So we give you the opportunity, but if you don't know who to strike, then we just go with the one at the top of the list. So let's just hear the 3 names that are there. Madam Clerk, can you help us with that?
That would be Keith Lawrence, Heather Kale, and Sherry Ebald.
Ms. Rhodes, do you care to strike any of those individuals?
I don't care to, Your Honor.
Okay. Mr. Jensen?
No, sir.
Okay, so I'll appoint Keith Lawrence. Keith Lawrence will be appointed to be the guardian ad litem. The next step with that guardian ad litem order is that I need to fill out a couple of things, and I'll just ask for your assistance. So the child's name, is it Nora?
Nora.
Nora?
Correct.
And Mr. Jensen, how old is Nora?
She's 13 months, 14 months.
Okay, so I'll just put 1.
Almost.
Okay. All right, so I filled out that order. I'll just briefly explain it to you. Okay, so I'm appointing Keith Lawrence to serve as the guardian ad litem. He's going to investigate all issues related to making a parenting plan for the child, and specifically I'm asking him to follow up with any substance abuse issues of concerns related to Mr. Jensen, and any other issues that that could affect the safety of the child. The guardian ad litem report will have a 30-day review if make sure the parties have complied and made contact with and got back in touch. And there's a form he'll fill out, send to you to fill out, and then you need to get that back to him. So I'm proposing that we come back on. We're setting the hearing for March 27th. That's a Wednesday at 9 o'clock to make sure that everybody's made contact and follow up and replied back to Mr. Lawrence.
So now that we have this guy, do I still need to go do that paperwork through the court?
Yeah, because at this point, your voice hasn't been heard.
Right.
And so Mr. Lawrence, his job is not to advocate for one party or the other. His job is to advocate the best interest of the child.
Right.
And that may be averse to either of your interests. So yes, you'd need
Right.
to submit something, correct. And then as far as an interim order for the court to receive Mr. Lawrence's report, Madam Clerk, timeframes for that is generally 6 to 8 weeks on an interim level. So that's what I'm kind of looking at. So today's the 27th. So that's 27th there. So I'm going to set the interim review for the 24th of April, April 24th at 9 o'clock. And that'll be just kind of the interim, kind of the initial, kind of it won't be the full report or the final report. It'll be just kind of the initial overview and say what he thinks at that point. So this order allows the guardian ad litem to talk to child care providers, physical and mental health care providers, any school or daycare providers. It also,
Can I take my phone out to put these dates in my calendar?
Sure.
Okay.
And then also that this, I'll ask both of you to sign the document at the bottom of this document, because by signing, then you're giving your consent for Mr. Lawrence to contact mental health providers, substance use disorder providers, and the like, so he's able to speak with them. It acts as a release of information or an ROI.
So we'll be coming back, you said March 13th after he submits his things, and then come back again April 27th?
Yeah, I changed things a little bit.
Okay,
March
sorry.
27th will be the date that we come back to make sure everybody's made contact with Mr. Lawrence. March 27th at 9. And then on April 24th will be the date when his interim report will be submitted, and we'll review that. I'm going to make it county pay, so the parties don't pay anything for it. So it's county pay. That's how Mr. Lawrence will be paid, is through the county.
Awesome, thank you.
And then so let's just take care of this now. I'll encourage, let's see, Ms. Rhodes, if you'll come up first and just sign on the left resources. You can take a seat. As far as resources, there's a website called WashingtonLawHelp.org. And if you look under there, under family law or divorce law, there's all kinds of forms, and there's actually kind of step-by-step guidance and directions that are there. So WashingtonLawHelp.org, both parties are able to access that.
If you go to the clerk's office, Chris, they will print out a sheet for you, and they will highlight the ones that you need to fill out, and then it has a link on the website, and you just go print them out. But when you come in, you need to bring multiple copies.
All right.
Otherwise, they will charge you to do it.
Yeah, that's a good suggestion. And then another option is there's something called the Clear Hotline. You can call that and talk to a licensed attorney and ask questions about that. And then once you've filled out all your paperwork, you can check it with a courthouse facilitator, which works with the clerk's office, and they can review your pleadings, the paperwork, to make sure you've got everything, you haven't missed anything. Oh, only when we finalize.
I need a copy for you.
So that's premature. So you check with the clerk's office, and you can also check that WashingtonLawHelp.org website. That will give you the forms where you can respond to the motion, and then you'll submit those. Make sure you get a copy to Ms. Rhodes, and then you have to fill out what's called an affidavit of service. Basically said, yeah, on such and such a date, these documents were given to her or were mailed to her. And then we'll be here on the 13th to talk about the motion filed by Ms. Rhodes.
Okay.
Any final questions?
No, that's it. Thank you, Your Honor.
Thank you. Touch base, make sure everybody's here. I have Alexandria Vaughn. Can you hear me okay?
Yep.
Okay, very good. And Mr. Zachary Kayoshi, are you here?
Yes, Your Honor.
Okay, very good. And Ms. Fellows is present as the guardian ad litem.
Yes, Your Honor.
All right, good morning.
Good morning.
All right, one moment. So we are here on the motion related to the parenting plan, and work schedules and Head Start are some of the issues that need to be resolved. So maybe I could first hear from Ms. Fellows and then hear from Ms. Vaughn and then from Mr. Kayoshi, if we can proceed in that fashion.
Yes, Your Honor. I received the proposed parenting plans and the declarations from both parents, reviewed them, reviewed and looked over and wrote down the differences and what looks similar. I've also talked to both parties at length. And although there's a lot of issues as reflected, and there are differences and stuff like that, I was really able to talk with both of them about being realistic, and the work schedule and the Head Start and the week on, week off, and just a lot of those issues. What I can say is that both parents have been exceptionally receptive to the conversations and to really as the GAL, my expertise on what's realistic and really trying to look at the other side, and just looking at everything as a whole. So in essence, what I would say is that I think that there's much more of a meeting of the minds now since having those conversations. I definitely give kudos to both of these parents. I will also say that when they each got the other's declaration and proposed parenting plans, they were both kind of taken aback and shocked. And it took a while to kind of work through that. But what I can say is at this point, I think we kind of have some agreed things that I think that my thought would be is to kind of make a few changes to the existing visitation, potentially see how that goes for, say, about a month or two, and also I would like to be able to continue working with the parents to try to basically come to an agreement, and maybe like in, say, 60 days, being able to talk with both of them, trying to iron out some of these issues, potentially being able to come back to court and they would have agreed parenting plan.
Okay. So I'm assuming there's agreement at the exchange is going to be at exit 72, the Love stop.
Yes. Right now the visitation is Tuesday overnight to Wednesday. They do meet at the truck stop at exit 72. My thought was to have the visit remain Tuesday overnight to Wednesday, but increase in time. What the court had ordered, I think, was 24 hours, 6 p.m. to 6 p.m. Tuesday overnight to Wednesday. However, that impacted upon Dad's DV class. So I worked with the parents to basically shift it 24 hours. So like, I think it was 1 p.m. to 1 p.m. And the pickup is, or the exchange is at the exit 72. They've been working together doing that. And what I can say from Mom in particular is, after having the conversation with both parents that I've just recently had, she commented to me when I did talk to her yesterday, is that there seemed to be some lightness to the exchanges, that they're getting better, and that there seems to be, they're just getting along a little bit better. And I think that having this process and me being able to talk with them and just kind of, talk things through about, they both love their son and their son is their primary focus, and, what's logical and that kind of stuff. So my thought would be is like Tuesday at 11 a.m. Mom has counseling on Tuesday. So she feels like she would definitely be able to get Corey up to the exchange spot at 11 a.m. on Tuesdays, and then go until Wednesday, overnight to Wednesday at 6 p.m. She works on Wednesdays, but she gets off in time where she could get up there to the exchange spot. So that is my recommendation at this point in time, maintaining that Dad and anyone around the child not be under the influence of alcohol, marijuana, or kava, and then potentially look at a review with the idea of coming back with a final parenting plan on May 1st is my thought.
decision-making, it sounds like the parties are communicating well, and was that part of the recommendation?
Well, at this point, I have talked about decision-making. I know dad wants joint, mom wants sole. Given that there is the distance between mom and dad. Mom lives here in Longview, dad lives up in Olympia. Also is that their communication is just starting to get better. And so I really feel like mom being sole decision maker makes much more sense, but that dad be allowed to have contact with medical providers, school, that he have that information and be able to access that information. In my conversation yesterday with mom was like, if we're doing the exchange on Tuesdays, then she could possibly do, if appointments are available, appointments on Tuesday. Dad could come down, attend those appointments, and then take Corey back up with him. That was her suggestion, which I give her kudos for. So that to me shows that there is forward movement in their communication and ability to co-parent. They're on the beginning stages. They're our family wizard. I do have access to it. Their communication has gotten much easier and much more friendly. But again, they still do have a ways to go. So I really want to not put the cart before the horse, give them some more time to kind of work through this, see what they're, see how things go. And there is the distance, and there is dad's work schedule, which it is what it is, which is what I told both of them. And it's not fair or right to ask dad to change his work schedule at this point in time. It's also the week on, week off. As a GAL, I would not recommend that at this point in time. He's a 3.5-year-old right now. He just started having in-home visits and overnights with dad. So that's a big leap. So I talked to both parents about this, and both of them were receptive. We did butt heads a little bit, I will admit, but they understood where I was coming from and were able to basically agree to a certain extent. I mean, they may have other things that they would really like to see happen, but I did let them know from the GAL perspective where I stood.
Thank you, Ms. Fellows. All right, Ms. Vaughn.
Yes, John.
Pretty much just what Beth said. I think right now him having Tuesday to Wednesday, those are his 2 days off from work. That works the best when it comes to trying to juggle all the schedules. I did offer him to have a little bit more than 24 hours by giving him the 11 a.m. I have an appointment from 9 to 10 every Tuesday. So 11 is about the earliest I could get the kid there. And then I do get off at 4 Wednesdays. So pick up at 6 would be fine at the halfway point. I agree with her about the decision-making, me having the sole primary decision-making, but with the limitation, so to say, that I keep his dad informed, which I have no problem doing. I have done that via our family wizard this whole time. I have no problem continuing that. But I do agree that right now we're not necessarily at a place that I think me and him could mediate between the two of us. I do think we do need her or somebody of that nature to kind of buffer a little bit. We're just starting really to even be able to talk to each other, it feels like.
Okay. Thank you. Mr. Kayoshi?
Yeah, I think we're moving forward. So yeah, I think we're all three of us. I mean, we're in a good place of communication right now, and I'm not arguing that. But I did write. So I had some thoughts I wrote out just so I wanted the court to hear. I wanted you to hear, and it's nothing that I haven't already talked to Beth Delos about, and I'm sure she might laugh when she hears this. But so right now, this is looking at both parenting plans. These are when I did my my parenting plan up, and she did hers. I did my declaration. I had more thoughts I didn't want to throw into there, but I will say here in the court today. So right now is the most time I am going to spend with Corey before he starts kindergarten. The GAL says moving to week on, week off visits before he starts school is too big of a change for Corey. But still, my time this all started because Alexandria did not have said I did not have a relationship with our son, which was not the case. But still, my time was immediately cut to 2 hours supervised visits, then 6 hours with county restrictions, to 8 hours for 2 weeks. And now I get him overnight before this court hearing, which I should have had him overnight 3 weeks or 3 times before this court hearing, which did not happen. Once because he was sick, and I get that if he's sick, depending on how sick he is, I don't want him to be moving back and forth between me and his mom, especially when the commute is an hour away. So 2 years later, so now looking back at everything that I've done that the court has asked me to do, 2 years later, I'm still restricted and unable to take care of our son when he's sick because of transportation, which I understand, but it's still limiting my responsibilities and duties as a father. The GAL disagrees with the proposed plan of holding off kindergarten and allowing the week-on, week-off visits to take place, which I disagree with because it would help me build a better relationship with Corey before he starts school and starts seeing new and different faces outside of his own family. This is the most time, like I said, I'm going to spend with him because he is not in school. I've done everything done everything for this very moment to be able to take care of him as a father. Everything I've learned from the parenting class that was court ordered, I can't even implement and practice with our son because she's trying to put him in school so soon. If we would have stuck to the 8 hours visitation once a week, or even the overnights 24 hours once a week in total for the year, that's 1,152 hours out of a year, which is 8,760 hours. I miss out on 7,608 hours of the year. Now is my time to spend with Corey before he goes to school, and work schedules and school schedules limit that time for us drastically. The week on, week off would also help with both of us and childcare costs and set an easier schedule for both of us to make the pickups and drop-offs instead of having to do it every day, basically, to once a day for the week and then coming back. So I get more time with him, and it makes it easier for that transition of the pickups and drop-offs. Corey has a great time when he's here. He never wants to go home when I drop him off, but I don't hold him. I get him to go with his mom, and I'll tell him I'll see you later, in hopes that I do and he doesn't get sick and visits get canceled. He shows no indicators of mental distress from the changes we've made up to this point. I respectfully disagree with the GAL and would like to hold off on kindergarten and would like to move to week-on, week-off visitation until he starts kindergarten and spend more good quality time with our son. And if need be, she can come up at any time to see those interactions because I think it might help the court and help everybody to see what I see when he's up here. And then I just said I do not want to be a father that just pays child support. I want to raise my own son as well.
Thank you, Mr. Kashi. I appreciate that.
Yeah, sure.
All right. Well, I appreciate the input from all parties, and I'm especially encouraged to hear that the parties are communicating better. And I can only tell you that just from my experience of what I've seen, when parents are working really hard to communicate with each other, that only benefits their child. Because when they see mom treating dad with respect and they see dad treating mom with respect, that child feels respect. Because the way you treat the other parent, the child interprets that as the way you're treating them, because they're half of that other parent. So when you're kind, when you're respectful to that other parent, and you speak in positive terms about that parent, you're actually causing positive benefit to go to that child. And the reverse is true. When you're negative or disrespectful or speak poorly of the other parent, the child internalizes that as negative talk to them because they identify with the other parent because they want to please that other parent. And when the other parent says poor things, speaks poorly of the other parent, the child internalizes that as they're speaking to them, and that's negative to them. So I congratulate the parties on the progress you're making with the communication. That's absolutely key. And Mr. Kayoshi, you mentioned your proposal is a 50-50 plan, so splitting it in half for each parent. I think that's important in a lot of situations. That works perfectly and works really well for the child, and the child is blessed by the benefit and the input of both parent. One thing to keep in mind also is that stability and gradual change is generally good for most children. Abrupt changes are more difficult for children, and those adjustment periods, we try to smooth those over and minimize those as much as possible. So during any period of which the court is looking at a case, the court's going to carefully look at how the parties interact with each other. And if the parties are interacting well with each other, there's a greater likelihood that a 50-50 plan could be implemented. When there's a lot of strife, there's a lot of disagreement, and there's a lot of distrust, and the parties are not communicating well, 50-50 plans don't work. And the court is really not inclined to implement those because the parents are not getting along well, and you have to get along well. You don't have to like each other. You just have to be civil and respectful to each other, and then communicate well with each other. And if the court sees that, there's a much greater likelihood that a 50-50 plan would be put in place. So, with that, the work schedule, the kindergarten start time, and the like, those are important considerations. Ms. Vaughn has been raising Corey predominantly for the past few years, and Mr. Kayoshi's time has been limited, but it's starting up, and that's very much encouraged because both that little Corey's a boy, correct?
Yes.
Okay, just want to make sure because Corey could be a girl too. Corey needs the input of both parents. Happy children are children that have the good influence from both parents. And I think that's really important. So with the overnights just starting, I think it's important to continue that new schedule that the parties have kind of ironed out, 11 a.m. Tuesday to Wednesday at 6 p.m. And that, and appreciate Mr. Kayoshi's calculation of the number of hours in a year and the amount of time. And when you put it in those terms, that's pretty limited. It's pretty limited. So the court appreciates that. So the Tuesday, 11 a.m. until Wednesday at 6 p.m. would be Mr. Kayoshi's residential time with Corey. The exchange will occur at exit 72 of the Love truck stop. And I appreciate those exchanges. Your child is watching you always and picking up a lot of the nonverbal cues. So as much as you can be positive during those exchanges, that benefits your child. Because any negativity that's expressed towards the other parent, the child internalizes that and they take it on the chin because that's their half of their DNA is talking to them. Both parties are restrained from consuming mind-altering substances, period, during the time of their residential time. So that means any substance that would alter your mental state. As far as decision making, I've heard from the parties, and decision-making generally relates to health and education. So health issues, would include any emergency visits or maybe a rash that's unknown or a cough or things that aren't resolving, and a checkup occurring, the annual checkup or the well child checkups that occur. And then the education piece. I'm inclined to grant joint decision-making because I think it's going to foster the parties communicating and learning how to communicate again about important issues. And yet there's some reservation I have related to the kindergarten and Head Start. So I'm going to hold off on joint decision-making, but know that I'm inclined, if the parties continue to communicate well, to allow for the joint decision-making when we come back on May 1st. I think that's important that both parties have a say. And there may be divergent opinions related to that, and that's just something you have to work through. But it's important that both parties have opportunity to, and that perspective. With that said, I think that'll be the court order at this point in time. It's going to be a temporary order. It's a temporary order, if you will, parenting plan. In that when we come back on May 1st, there's going to be some more decisions related to holidays, related to the 50-50 plan or the limited plan that we have here, and then we'll probably talk about Head Start, kindergarten, and the like. So some decisions that are fairly important. Yes, Ms. Fun.
So Corey was already on the wait list for Head Start and was already offered a spot, and I've already requested that they wait until the fall instead of right now to put him in to allow his dad the whole summer's time. And with that, she said she would get me taken care of for intake likely in March. So I do need to have that answer like way before May 1st. I can't keep passing up positions, and this is the last one.
Well, you'll have to make some decisions on how to approach that, but it sounds like you have a spot reserved for the fall. and there's some intake in March, we'll be here back in May. If you proceed as planned, and then you have to change based on the court's decision, then that you'd have to make that change. But you move forward with whatever plans you have, and Mr. Kayoshi does the same until there's an order that intervenes or changes that. So I'll draft up an order that establishes that temporary parenting plan with the parenting hours for Mr. Kayoshi from Tuesday 11 a.m. to Wednesday 6 p.m. The exchange will occur at exit 72. The restriction of mind-altering substances, limited decision-making to Ms. Vaughn, and then the return date of May 1st. And again,
could it be, there hasn't been any concerns about mom and any substance use. It was actually dad and actually dad's family. So that was actually what was has been in the order before.
Okay.
So I would prefer it to be reflect what it has been before, that it be the father and the father's family, anybody around Corey during his time.
I'm fine with that. Okay. Any other comments from Ms. Vaughn or Mr. Kayoshi?
No, I mean, me and Beth did discuss if he's having anybody else in his home watch Corey, that they be registered through DCYF, just as my childcare provider is, just so that they're adequately trained.
So you're saying his mother or his father couldn't watch the child?
So she said it would be his sister, which was the same situation I had, and his family has all come into court. They've all been a part of the abuse. I just would like that they take these classes to instill the quality care that Corey deserves. His dad has taken them. I'm not asking his dad to do that, but whoever becomes his primary go-to caretaker be certified through DCYF.
I'm denying that. Seems overly restrictive. Any other questions?
And what I would say, Your Honor,
Just,
is
no.
that with
If you're going to
these
address that
visits,
issue, I've addressed that issue. We're not discussing that further. If you have a different issue, go ahead.
no, with these visits are for dad. And so dad will be taking care of Corey.
That's my assumption. And if, dad needs to run an errand, then somebody watches him, takes care of him, and dad comes back or takes his boy with him.
Yes, Your Honor. I just want to say one thing. I haven't used any substances, not even alcohol, and I understand her concerns, but I'm not going to leave my son with someone that I wouldn't trust to watch him. I wouldn't put him in harm's way if I'm not willing to do that. And I just want her to know that.
Okay.
Yeah.
Thanks. I'll draft up the order, and then I'll get that filed, and we'll be back here on May 1st. And again, I'm looking at the best interest of the child. Best interest of the child is served when parents are respectful and kind to each other and give the other the benefit of the doubt. And because that fosters a great relationship for a child. So we'll be looking for that to continue, and we'll be back here on May 1st.
Thank you, Your Honor.
All right, that concludes the matter for today.
Thank you, Your Honor.